When I initiated coverage on a biotech company called Halozyme, I had been a biotech analyst on Wall Street for about 10 years. I initiated coverage when the stock was trading at $1.86 a share and rated it buy because I had estimated that it was worth $2.88 a share. After I initiated coverage, my firm received an investment banking fee when the biotech company raised capital. Because my financial projections predicted the company would have to raise more capital in the future, it is understandable the investment bankers wanted to maintain a good relationship with the company's management. The stock price of Halozyme started to increase after the investment banking deal and went above the target price of $2.88, which I had established when I initiated coverage. Because a buy rating requires at least 15% upside from the price to the target price, I started looking for new information that might justify an increase in the price target when the stock price approached $2.50 a share. After several days of due diligence, including a conversation with the company, I informed some of my fellow analysts that I had decided to lower my investment rating from buy to hold rather than raise my target price. Approval of the Investment Policy Committee is a formality that analysts must obtain, but its purpose was primarily meant for junior analysts and initiation of coverage reports. I informed the members of the IPC on Friday, February 24th. While I knew that this rating change would be unpopular because the company was an investment banking client, from an analytical perspective it was an easy call because of the rapid rise in the stock price and the lack of new information that would justify a change in the target price. The first sign of trouble came when I was told that, for the first time ever, the head of sales would be joining the IPC. I knew then the head of sales would be upset because it was Friday and he had just spent weeks organizing a non-deal roadshow for the company management starting the following Monday. You can see the relative dates in the calendar here, with the initial downgrade decision on Friday in green and the non-deal roadshow on Monday in red. He asked me to delay the downgrade for a day and argued that I could talk with the management when they were here on Monday. I needed his vote, so I said yes. On that same Friday that I decided to downgrade the banking client and I'd been approached by the head of sales, I was also contacted by the senior investment banker at the firm. I figured these two events could not be a coincidence because it's blatantly against industry rules for a banker to pressure an analyst. On the call, the banker was pleasant but focused his questions on the investment banking client. Industry rules specifically prohibit investment bankers from exercising control over research analysts. But I was careful to answer the banker's questions but only provide publicly available information like the existing rating on the stock and the target price. The next day I received an email from the director of research, who had started in the industry as a retail stockbroker and had a reputation for being blunt. The email contained the phrase, "finesse the target price," and I was shocked that he had put such language in an email. I made it clear to the Director of Research in a reply email what I thought of his finesse request. After waiting the one additional day I had agreed to with the head of sales, I submitted a downgrade report by email to the IPC. I was metaphorically in between a rock and a hard place. On the one hand, the internal opposition to the downgrade had been even more severe than I had originally anticipated. On the other hand, the stock price was now well over my target price, and the second meeting with the company had given me no reason to change the target price. Shortly after I emailed the report to the IPC, I received the following email from the Director of Research, who had been on the email distribution list. It says that he won't let me publish the report even if the IPC approves it. I briefly saw him the next day and asked him what he meant by illiterate, and he muttered something about mistakenly opening the Word document in the revisions mode, shown in this slide, in which all the previous additions and deletions are shown superimposed on the document. I reminded him that the IPC was the proper forum to communicate comments, and that I had already delayed the downgrade by a day to accommodate the head of sales. He refused to give me an IPC. It had now been almost a week since I started the downgrade process, and I was getting calls from clients asking me what they should do with the stock. Frustrated by the delays, I contacted a lawyer, and I was told that I should ask to have my name removed from coverage of the stock and cite Regulation AC. I sent 2 different emails to the head of compliance of the firm with this request. 2 days later, I was removed from the research department and reassigned to a new role at the firm. While I was upset, the firm did continue to pay my salary and travel expenses, so I knew that at least I hadn't been fired. By this time, I thought that Rodman had violated at least 3 regulations. NASD Rule 2711 not only prohibited investment bankers from influencing research analysts, but it also prohibited investment banks from retaliating against analysts for unfavorable research reports. Furthermore, since SEC Regulation AC now required analysts to sign attestation statements that legally bound them to the opinions expressed in their research reports, I assumed that Rodman had violated the law by not allowing me to have my name removed from coverage. The investment bank later stated in court documents that Regulation AC doesn't, quote, require a firm to remove an analyst's name from coverage simply because he demands it, end quote. So I decided to report the emails to Congress. I had once interned for Senator Grassley, who at the time was chairman of the Senate Finance Committee, and my cousin was a lawyer on that committee staff. When I showed him the emails, he asked for copies and also asked me to show the Democratic staffers. When I got back to New York, I told our partner at the firm that I had reported the emails to Congress. 2 business days later, I received this termination letter and a call from the head of compliance making sure that I had received the letter and that I wouldn't show up for work the next day. 2 articles were written on my story by Gretchen Morgenson at the New York Times, who had received the Pulitzer Prize in Journalism in 2003 for her reporting on the Wall Street Global Settlement. This made her very qualified to understand my situation, since the Wall Street Global Settlement resulted from Eliot Spitzer's investigation of fraud by Wall Street analysts like Jack Grobman and Henry Blodgett, and resulted in the SEC passing Regulation AC. The Senate Finance Committee launched an investigation into my termination and concluded that I had been fired for reporting the emails to Congress. Unfortunately, the National Whistleblowers Act of 1989, which ironically was co-authored by Senator Grassley, only protects government employees. New York State has a Whistleblower Act, but that only applies to members of the healthcare industry. The Senate Finance Committee sent a bipartisan letter to the SEC asking them to investigate the violations of SEC and NASD regulations by the investment bank. The SEC under Chairman Chris Cox investigated the investment bank but decided not to prosecute them. There have been no prosecutions under Regulation AC since it was passed in 2003. After the SEC dropped the case, FINRA launched an investigation. After interviewing me and the investment banker's lawyer, but not Mr. Vasinkovich, FINRA investigators concluded that I had threatened the investment banker on the call and issued me a warning letter. FINRA arbitrators sided with the investment bank, which asked for $25 million in damages, and it ruled against me on multiple counts, including defamation and tortious interference. Testimony given under oath during the arbitration contradicts the conclusion that the FINRA investigators came to and implicates Mr. Vasinkovich in perjury. No evidence was ever introduced that I benefited financially from my actions or had motives other than to clear my name. The financial award from the arbitration panel has to be signed off on by Judge William Pauley, who is the federal judge who signed off on Eliot Spitzer's Wall Street Global Settlement in 2002, which ultimately led the SEC to pass Regulation AC.